Hey everybody, it's Christopher Small with CMS Law Firm. Here today to talk to you about how to make somebody do something that you want them to do with your stuff after you give it to them via your will, right? Translation, how do you get people to do stuff after you've died, okay? Via your will. And I want to talk about this because it came up today with a client and I get questions about this often, and it's a really, really important sort of aspect of estate planning to know and understand as you consider what to do with your own estate plan. By the way, if you have specific questions, please go to estatemeeting.com, set up a time to talk with me for free. I answer your questions, talk about your family, talk about your goals, and I give you some ideas on how to get there. All right, estatemeeting.com. But they, in this particular case, probably the easiest way to talk about this is with an example. They had a piece of property and they wanted to give the property to a friend. Let's say that friend's name is Julie, and they wanted their nieces and nephews to be able to use the property after they were gone, and also have Julie use the property after they were gone, and give the property to Julie outright, but also make sure that if Julie ever got divorced, that the property was not community property to be split with her spouse. And also, if Julie ever decided to sell the property, they wanted to have the proceeds of that property split 50% to Julie and 50% to the nieces and the nephews. And as that request came in, I saw it, I looked at it, I tried to figure out a way to do it. And the problem is, the major obstacle you are going to encounter with your estate planning, if you are trying to set something up like this, is that when you utilize a will to distribute your property after you are gone, what you're going to get is two things. You're going to get certainty that your property is going to go where you direct, but you're also going to have or get zero control over what happens to that property after someone gets it. Okay, so for example, another example that I see all the time is people want to give money to someone, and they say, but I only want this to be used for education, or I only want it to be used for down payment on a house, or I only want it to be used for fill in the blank, right? It doesn't matter. And what I have to tell those people is like, look, they're going to get that money if you do it via will, and they're going to spend it however they want, and you're not going to be able to do anything about it, and no one else is going to be able to do anything about it either. So to go back to this example with the property, in Julie, if Julie gets the property outright, then there's no real way to ensure that all of the things that the client wants can actually happen. Because once she owns the property, she's not under any obligation to split the proceeds. She's not under any obligation to share the property with the nieces and nephews. And although you could write something in to allow for that, it's really difficult to do that and give Julie the ability to sell the property whenever she wants at the same time. All right, so it just gets kind of messy. However, there is a solution. By the way, you can have access to all these solutions too, and we can talk about your specific needs, goals, and wants if you go to estatemeeting.com and set up a time to talk to me for free. All right? So the solution is actually relatively simple. It's relatively straightforward, and it will accomplish all of the goals that you want. This solution is a revocable living trust. I kind of wanted to go dun da da da, but I didn't, although I just did. But that is the solution, a revocable living trust. The reason that works as a viable solution is because you can check all the boxes, basically. The property is going to be held in trust. There's a trustee, like a third party, that's there to manage, oversee the property, but also has the ability, not only the ability, but the duty to follow the rules that you have set with regard to the property and whatever else you've put into the trust. So in that case, you drop this property into the trust and you tell the trustee a couple of different things. Thing number one, Julie and the nieces and nephews have the ability to utilize the property together. You can either, you could set out a specific schedule or if you wanted to, or you could leave it to the trustee to set that schedule. Like, hey, nieces and nephews, you get 52, you get 26 weeks a year. Julie, you get 26 weeks a year, right? So you can split it up like that. Then you could also say, Julie has the ability to direct the sale of the property at any time. She has that right. However, when the property is sold, the trustee is directed to distribute those proceeds, 50% to Julie and 50% to the nieces and the nephews, right? So in that case, you get to have your cake, you get to eat it too. The other thing, by the way, is that while that property is in trust, it's going to be protected from any bankruptcy action, any lawsuit, divorce, anything that Julie sort of would have happen in her life. This property is going to be safe from that because it's in the trust. It's not considered to be a part of Julie's property. And so all of that safety and all those protections that you might want are there as well. So that's that. That's how you do it. So if you're really wanting to have control over the asset or over an asset post-death, the will is not the way to do that, because the will is going to simply transfer the property outright to the person that you want to transfer to. Okay, if you want to have extended control, extended management, extended oversight, then you're going to want to use a revocable living trust. And if you want to know more about that, if you want to know how that can fit into your own specific situation, please go to estatemeeting.com. You can talk to me. You can talk to Ella, who's another attorney in my office, and we will set you straight, hook you up with all the details, show you how we can make this work for you, and then you can decide if you want to implement it or not. But knowledge is power when it comes to estate planning. The more you know, the better you are. The more informed decisions that you can make. And that's the number one goal of all of us over here at CMS Law Firm. Okay, that is it. As always, if you like this video, hit the like button. If you have a question, comment, please put it down below. And if you know someone that should hear this, please share it with them, okay? If you're not watching this live or you're not watching this on video, if you're listening to it on podcast, email somebody the link. Tell them, hey, I thought you might like to know this, right? That's it. Once again, I'm Christopher Small with CMS Law Firm. Thank you so much for your time. And I will be here again tomorrow to talk more estate planning.